Today I'm going to discuss a particular immigration case that involves divorce and how that would impact somebody who's waiting for a visa to become current in the F3 versus F1 preference category. Let me explain the situation and see if this interests you and connects with what's going on in your particular case. This woman who came to me is an Indian national who was referred to me by one of my all-time favorite clients. And so she says here, this is her question. She says, my mother petitioned for me on June 22nd, 2015 under the married son-daughter over 21 of a USC F3 category, which needs to be converted to an unmarried son-daughter over the age of 21 USC F1 category since I've been divorced. Would converting to the F1 make the process faster? She goes on to say, as per the June 2020 visa bulletin, currently F1 case for India, February 2015 cases are being processed, and my priority date is June 22nd, 2015. Hence, we thought it would be beneficial to request USCIS to change my file's category. Okay, so let's unpack this. Before I do that, if you don't know me, my name is Josh Goldstein. I'm an immigration lawyer in Los Angeles, and I help people across the country and around the world get immigration benefits, work permits, green cards, U.S. citizenship. I'm particularly committed to helping people who have delayed immigration cases, and I do that by filing mandamus lawsuits against USCIS and consulates around the world. Okay, so let's unpack this. First of all, let's go to the visa bulletin. If you don't know about the visa bulletin, you can find this online. If you just Google visa bulletin, it comes out every month. The State Department publishes it, and the visa bulletin is it kind of gives you your place in a long line. Where are you if you're waiting for a visa to become current? Where are you in this line? That's the question that the visa bulletin answers. And you'll notice that for family-sponsored preferences, you have the F1, F2A, F2B, F3, and F4 category, and they're described here in this section. And these are all the preference petition categories. And then each month you'll see here, it tells you which one is current. And there's separate categories for China, India, Mexico, the Philippines, and then every other area except for those. So our particular, the person asking this question is an Indian national. So she started off as an unmarried son and daughter of a U.S. citizen. She was married, a married son or daughter of a U.S. citizen. So she started off in F3. Now, F3 category for July 2020, they're working on cases that were filed in May of 2008. So since she's gotten a divorce, she would move into the F1 category, which is currently focused on the current priority date for July 2020 is July 14th, 2008. No, sorry, July 8th of 2014. So the answer to her first question is, would converting to F1 make it faster? Yes, it would make it faster. F3 is on May 2008, and F1 is July 2014, and that's a good 6 years faster. So that would be good. A couple of things I want to say about the divorce. First of all, the divorce must be a bona fide, legitimate divorce. Sometimes people who are married and they're in the F3 category will get a divorce solely for immigration purposes, just so that they can obtain a faster green card. And if you do that, you're going to destroy all your immigration chances, because that's fraud. A divorce should happen for bona fide reasons. There was a breakdown in the relationship, things of that nature. You don't want to just run out and get a divorce just so that you can get a green card a little bit faster, because that's fraud and that'll come back to bite you. Secondly, what do you do? How do you actually move your file from F3 to F1? Well, I think what you would try and do is send a letter to USCIS or to the National Visa Center, depending on where your case is, and send them a copy of the divorce decree, send a letter to them along with the approval notice or the receipt notice for the case. It's very difficult to communicate with USCIS or the National Visa Center by sending a letter, but I think this is the procedure that you're supposed to follow in order to try to get them to change your classification from one category to the next. A couple other things I want to point out, which is that for someone, her case, there was an employment-based component to her case, but for someone wanting to get a green card through a preference petition, that is to say, the adult child of a U.S. citizen, in order to do that through the adjustment of status process in the United States without returning to your home country and going to a consulate, in order to do that in the United States, you have to be in status the entire time. You have to be in status at the time you are applying for adjustment of status. So as we can see, this person here, her case is not going to be current for some time, maybe another year, because her priority date is June 2015, and they are working on now July 2014. So she could have about a year to go. The visa bulletin does not progress in a linear way, so every month it could go forward, it could retrogress, it could jump ahead. So we don't really know how long it'll take, but it could take about a year. So in order for her to get a green card through adjustment of status, she would also have to be in status at the time she applies. And if it's a year or so away, she's got to find some way to remain in status. That could prove tricky. If she were to leave the U.S. and consular process, then we have another problem, which is that Trump is messing around with visas. The consulates claim to be closed for the coronavirus, and they've been closed for some time. And also he's set out with his presidential proclamation, which is preventing the issuance of visas. And a year from now, who knows where we will be. Trump might not be president. Trump could win the election and be inaugurated for a second term, and he could come out with all sorts of new regulations that would mess with the visa issuance process. So there could be some bumps ahead. Those are my thoughts on this particular case, this particular scenario. If your mother or father petitioned for you when you were married and then you got a divorce and you want to change from F3 to F1, this gives you a good overview of what the issues are and how you would do that. If you have questions, let me know. Get in touch with me. I can answer your questions, help you out, or point you in the right direction. Thank you so much for your time. Keep fighting for your immigration goals, and I will see you in the next video.